Hearing the appeal of the Queen against C.
Now, there are a number of preliminary matters that we need to deal with. First of all, there's an issue in relation to the live streaming of these proceedings. It's the almost invariable practice of this court to have its proceedings live streamed on the internet. But it appears to the court that in the circumstances of this case, which is an appeal from a preparatory hearing in criminal proceedings, in other words, a hearing before the trial, that Section 37 of the Criminal Procedure and Investigations Act of 1996 prohibits the broadcasting of a program which would contain more than the very limited information about the circumstances of the case. And the provisions defining what's involved in what's meant by a program would appear to cover the live streaming of these proceedings. So, subject to anything that the parties would wish to say, it appears to the court that it won't be possible for these proceedings to be live streamed. They will be filmed, and the film recording of the hearing will be available once the criminal proceedings have been concluded. But for the reasons I've explained, this hearing before us today will not be live streamed on the internet. The second preliminary matter concerns the terms of an order to be made under the provision that I just mentioned, and I understand that the parties are content with the terms of the order that the court has prepared.
Look, we are.
Well, in that case, I should read it out. The court has ordered that, in accordance with Section 37 of the Criminal Procedure and Investigations Act 1996, the following reporting restrictions continue to apply. Until the conclusion of the criminal proceedings or further order of this court or of the Crown Court, nothing may be reported except the following: the identity of the court and the name of the judge, judges in this case, the name, age, home address, and occupation of the accused, the offences or a summary of them with which the accused is charged, the names of counsel and solicitors engaged in the appeal, and whether for the purposes of the appeal representation was provided to the accused under Part 1 of the Legal Aid, Sentencing and Punishment of Offenders Act of 2012. Those details all reflect the terms of Section 37. Now, having got those out of the way, I'm afraid there is one more preliminary matter that we have to raise, which is of greater significance to counsel. It concerns the nature of the charge in this case and the arguments of the parties. Now, the charge is of an offence under Section 4.1 of the 1883 Act, and it deals with both the making of explosives and the possession of explosives. And it provides that, reading it short, any person who makes or knowingly has in his possession any explosive substance, under such circumstances as to give rise to a reasonable suspicion that he is not making it or does not have it in his possession for a lawful object, shall, unless he can show that he made it or had it in his possession for a lawful object, be guilty of an offence. Now, subject to counsel's submissions, our preliminary impression is that the offence created by the Act can take one of two forms. It can either be an offence of possession without a lawful object for possession, or it can be an offence of making without a lawful object for making. The charge in this case is not entirely clear as between those two, in that the particulars of the offence, well, the offence is stated as making or possession, and then the particulars of the offence are that the accused knowingly had in his possession an explosive substance in such circumstances as to give rise to reasonable suspicion that he had not made it for a lawful object. And when you read the judgment of the Court of Appeal, they have focused on whether possession was for a lawful object. When you read the statement of the defence case, it's to the effect that it was made for a lawful object. Now, we need to be clear as to what exactly we're dealing with, otherwise the arguments don't engage with one another.
Well, we had noticed the apparent difference between the making and possessing, but for our part had come to the conclusion, perhaps prematurely, that the hybrid form probably was not incorrect and that one may make it and continue to possess it. And indeed, so far as the statutory defence was concerned, it made no difference, because the lawful object which the appellant relies upon would apply both to the making and possessing.
Well, it would give rise to different considerations. Making it for the purpose of self-education or experiment is concerned with the mixing of the
Yes.
substances, obviously, the raw materials.
Yes.
Now, if you're talking about possessing it for the purposes of experiment, presumably you're going to detonate it.
Yes.
Yeah.
That was the appellant's defence, indeed is the appellant's defence. It comprises a combination of making it and detonating it in his back garden in order to confirm the correctness of the chemical experiment that he was carrying out in his garden shed. So we have approached the charge, the hybrid nature of the charge, in that way, so as to present the defence as dealing with both the making and the possessing.
So the object was the same in both cases, is that right?
Yes.
So the burden would be on the defence to show that there was a lawful object both in possession
Yes.
and in making.
Yes.
So are we to understand the defence statement, when it says the defendant made it for a lawful object, we're to read that as if it said made it and possessed it?
Yes, indeed.
And are we to read is the indictment? I mean, I'm not sure quite what we're meant to make of that. It doesn't charge the defendant with making substance unlawfully at all. Although it speaks of a reasonable suspicion that he had not made it for
Yes.
I mean, logically, if the offence is meant to be with which the defendant is charged is meant to be knowingly having it in his possession, then one would expect to continue to read in such circumstances to give rise to reasonable suspicion that he did not have it in his possession or under his control for a lawful object. And we needn't then be worrying about why he made it, or what constraints, legal constraints there might be on the making of the substance, but rather we'd be focusing on effectively the detonation of it, the possession of it for the purposes of detonating it, and you would then be concerned with what legal limitations there are on a person's ability to detonate a small quantity of explosives.
Well,
But perhaps we should hear what Mr. Mabley has to say.
I mean, could it be, I assume it could be, with agreement, it could be amended to get it into
well,
whatever was thought to be the right.
my Lord is right. As I say, we had not taken the point
Yes.
because it seemed to us that the defence was the same
Yeah.
regardless. And if, for example,
So I was just saying, I just want to make
Yes.
sure that amendment, as far as you're concerned, amendment would be a possibility. We'd need to look at
we would have no
mechanics of it.
objection to an
Yeah.
amendment
Yeah.
if the indictment had read and
Yeah.
or, we would have no objection, or if there were
Yeah.
two counts, one alleging the making and one alleging the possessing, we would have no objection.
I mean, you're all keen to get on and get the matter decided. So.
The position would make no difference, we respectfully
Thank you.
suggest, to the submissions that we make.
Well, it might make a difference to the Crown's submissions, because it may be that you can experiment with making this substance without committing any offences, other than the one with which you're charged.
Yes.
But depending on the quantity of
Yes.
the explosives, well, I mean, I don't know the details of all the offences in the statute book relating to explosives, but whether it's a lawful object to detonate the product of the experiment might depend on whether detonating it would involve committing some
Yes.
other offence, and that might depend, for example, on the quantity involved and where you detonated it and so forth.
Well, the respondent has raised that, and we propose to deal with it during the course of these proceedings.
Yes.
But as I say, we don't regard the manner in which it has been indicted to represent any prejudice to us
No.
at this stage. It may be that in due course, or indeed at some later stage, that there will be an amendment. But for the principles for which we contend, we suggest that if flawed, it's correctable, and we have no objection to it proceeding on that basis.
And you would be content with us to deal with it on the footing
Yes.
that we're dealing with an offence of possession.
Yes.
Mr. Mabley.
My lord is correct. There is a defect in the indictment, and the prosecution will have to seek to amend the indictment to ensure that there is no mismatch between, on the one hand, the possession which is charged and the conduct that gives rise to the reasonable suspicion. And as my lord has said, the reference to the reasonable suspicion ought to be relating to the possession. It's a possession case. Now, whether the Crown would also seek to add a making count is something that can be considered in due course, but my lord is quite right that there is a defect that will have to be corrected, but it's a possession case. That's the first point. My lord, so far as the second point is concerned, the respondent would agree that the object which is raised in the defence statement is the same for both, in fact. But the respondent would be content and would say to the court that this should be dealt with on the basis of possession, although the answer may be the same in this particular particular case in relation to any charge of making.
Very well. So we deal with it as a possession count on the basis that the Crown intends to seek permission to amend the indictment to turn it into a possession count.
So it would, the particulars would, would then read, knowingly had in his possession or under his control a substance in such circumstances as to give rise to a reasonable suspicion that he did not have it in his possession for a lawful object.
Quite so, my lord, yes.
Thank you.
Thank you very much.
My lords, it's a little late now, but may I introduce myself as representing the appellant and Miss McIntyre also, and for the respondent, Mr. Mabley and Mr. Worthing. Your Lordship should have three bundles, a core bundle, a bundle of authorities, and the appellant's case and the respondent's case. Unfortunately, as a result of the expedition of these proceedings, time was very short and it was not possible to assemble the bundles in the traditional form, and I hope that we might be forgiven for that. In addition, there have been some late additions to the bundle. Very late in the day, we realised that the copies which the court were provided with contain the Explosive Substances Act 1883 in its original form only, and we have introduced into Bundle 2, the Authorities Bundle at tab 16. We hope it's found its way to your Lordship's bundles, the current version of the Explosive Substances Act.
It doesn't look as though I've got that. I've got a Queen's Printer's copy.
And behind it, we had
It looks like it's
sent to the court some
more bundle.
some days ago, current version. I do apologise.
Yes, I think we got that towards the end of last week.
Thank you. In fact, the only substantive change is to the sentences, and so that the original edition is, to all intents and purposes, perfectly usable. There were also some further pages which were, or should have been added to the explosives regulations, and then a friend asked that those further documents be added, and those should have been added to the Authorities Bundle, tab 18, together with Section 33 of the Health and Safety Act 1974.
Well, when we come to them, I may have to ask for help.
I fear that they may not have found
Sure, it's my fault.
that their way to all of your Lordships. We, I'm sure, will have copies available if necessary. Your Lords, the appeal, as your Lordships will appreciate, concerns the expression lawful object, which is used in Section 4 of the Explosive Substances Act 1883. It's used both as part of the elements of the offence and as part of the statutory defence. And the respondent has contended and continues to contend that the defendant's defence as to lawful object is untenable in law. My Lord has already read out the content of Section 4.1 of the Explosives Substances Act, so I don't repeat it now, but it may be worthwhile considering for a moment the certified question, which lies at the heart of this appeal. And, Lords, that's in the core bundle, tab 6, at page 68 in the paper bundle, and at E85 at the electronic bundle. The point of law certified is this, that for the purposes of Section 4.1 of the Explosive Substances Act 1883, can personal experimentation or private education, absent some ulterior unlawful purpose, be regarded as a lawful object? And it's our submission that the reason that the court is now faced with this question is because an unnatural and an unwarranted gloss has been placed upon the meaning of the term lawful object, which is, we respectfully submit, quite straightforward.
Can I ask, while we're looking at page 68, there's a prison index number. Is the defendant in custody?
He remains in custody.
How long has he been in custody?
I think it is in the region of 21 months.
Has there been application for bail?
Well, we had considered making an application for bail as soon as leave was granted. We were waiting to see.
I was wondering in the courts below, in the Court of Appeal.
Not in the Court of Appeal.
No, okay.
One has not been made.
Right.
Lords, the circumstances of the prosecution
So
appear-
effectively, he would have to receive a sentence of 3.5 years. He served the equivalent of
Yes.
a 3.5-year sentence.
We appreciate that. In fact, it doesn't appear in the papers, but there was a further count on the indictment relating to the possession of an imitation firearm, which was a torch that doubled as a stun gun. And it appeared to us that might involve inevitably a custodial sentence, and therefore, while we accept that this appeal has taken a very long time to get to this stage, and that the appellant has effectively served a substantial sentence already, we did not believe that in the circumstances bail would be granted for what, in effect, with the charges under the Terrorism Act, which are consequential in some ways upon the determination of this case. Facing those charges additionally, we did not believe that a bail application would have been successful. Having said that, we had considered one a few weeks ago, and once we learnt that the appeal was to be expedited within weeks of leave being granted, we decided that, again, it would not be worthwhile making the application in the light of the fact that there were only weeks before this appeal was to be heard.
Yes.
We had hoped, I should add, that this matter would have been dealt with very much more quickly than it has. But for whatever reason, it has taken a substantial amount of time to get to this stage. My Lords, the statements of facts and issues are in the core bundle at tab 3, page 58 in the paper bundle and 67 in the electronic bundle. I don't know the extent to which your Lordships require me to deal with the details contained in that. In short, the appellant had been purchasing chemicals online in order to carry out the experiments, the subject of the counts on the indictment. He had, as I have set out by way of background, an obsessive interest in military matters, had a collection of BB guns and a collection of military clothing. He became somewhat obsessed with a film, as a result of which involved explosives and a unit of US servicemen dealing with explosives in Iraq, and as a result acquired materials in order to experiment and to educate himself.
Experiment by making explosions in his back garden.
Yes.
Is that correct?
Yes, by concocting the substance in a makeshift laboratory in his garden shed, and then detonating them in his back garden. The detonations which had already taken place, he recorded on his mobile telephone. The defence statement, again, to which reference is already made, is at paragraphs 3.2 to 3.3, which is at pages 61. No, in fact, it's at pages 61 of the paper bundle and 70 of the electronic bundle. Which concludes with the assertion that for the avoidance of doubt, the defendant's object or objects encompass interest, education, and experimentation. In other words, before I refer to Section 4 in further detail, it's our submission that it would be of help to the court to set out the legislative context of Section 4. And we submit that it provides a clear steer concerning the criminality or otherwise of the conduct disclosed in the Statement of Facts and Issues. By the late 19th century, Parliament created a comprehensive and coherent series of laws attaching to explosive substances and gunpowder. Essentially, one set of statutory provisions relating to explosives that might loosely be described as criminal activity, and another set of statutory provisions where there was no ulterior criminal purpose, but provided for the regulation of the manufacture, possession, storage of explosive substances with penalties for breaches. And if I may deal with the criminal laws first, I don't suggest it's necessary to go back beyond the Act, but the first Act I refer your Lordships to is the Offences Against the Persons Act 1861, and that is at the Authorities Bundle, tab 11, page 106. Electronic Bundle, page 277. The offences involving gunpowder and explosives are found at page 108 in the paper bundle and 279 in the electronic bundle. The first, as enacted, was Section 12, destroying or damaging a building with gunpowder or other explosive substance with intent to murder. Of the offences in the Offences Against the Persons Act 1861, that alone, amongst the gunpowder and explosive substances offences, has been repealed. The remaining offences are found at page 111 of the paper bundle, 282 of the electronic bundle. And they are sections 28 to 30. Section 28 being unlawfully and maliciously burning, maiming, disfiguring, disabling or doing any grievous bodily harm by the explosion of gunpowder or other explosive substance. Section 29 on the same page, unlawfully and maliciously causing gunpowder or other explosive substance to explode with intent to burn, maim, disfigure, disable, or to do grievous bodily harm. Section 30, unlawfully or maliciously placing or throwing gunpowder or other explosive substance into, against, or near any building, vessel, or ship with intent to do any bodily injury. And finally, section 64, which is at page 118 of the paper bundle, and 289, the electronic bundle, by which it is an offence to have possession or to manufacture gunpowder or explosive substance with intent to commit any of the felonies in the 1861 Act. As I say, all of those offences remain on the statute book apart from section 12. The next criminal offence is the one with which the court is concerned, the Explosive Substances Act 1883, and that's at page 143, that's tab 12, page 140, I beg your pardon, that's at tab 16, page 143 and 327 in the electronic bundle. That was introduced in order to deal with the threat of Fenian terrorism and introduced, it should be added, at short notice. I think it was passed within a day or perhaps 2 days. The offences contained in that Act are firstly section 2 at page 144 and 328 in the electronic bundle. Any person who unlawfully and maliciously causes by any explosive substance an explosion of a nature likely to endanger life or to cause serious injury to property shall, whether any injury or to person or property has been actually caused or not, be guilty of a felony. Section 3 comprises two separate means by which the same offence may be committed, and they are A, unlawfully and maliciously doing an act with intent to cause by an explosive substance or conspiracy to cause by an explosive substance an explosion in the United Kingdom of a nature likely to endanger life or to cause serious injury to property. And under 3B, unlawfully and maliciously makes or has in his possession or under his control any explosive substance with intent by means thereof to endanger life or to cause serious injury to property in the United Kingdom, or to enable another person by means thereof to endanger life or cause serious injury to property in the United Kingdom. That carried then a maximum term of imprisonment of 20 years. That has now been increased to life imprisonment. And the third offence is under section 4, the one with which we are concerned. A person who makes or knowingly has in his possession or under his control any explosive substance under such circumstances as to give rise to a reasonable suspicion that he is not making it or does not have it in his possession or under his control for a lawful object, shall, unless he can show that he made it or had it in his possession or under his control for a lawful object, be guilty of a felony. And that now reads guilty of an offence, with a maximum term now of life imprisonment. And so by the late Victorian times, those two statutes comprised the criminal offences with which a person might be charged in relation to any activity involving explosive substances. Sandwiched between the Act of 1861 and the Act of 1883 was the Explosives Act 1875, and that is the Act which we say provides a regulatory framework as opposed to a criminal framework. My Lords, that's at tab 14. At page 133 and 313 in the electronic bundle. And as the preamble, which is at page 134, 314 of the electronic bundle, shows, it was an act to amend the law with respect to manufacturing, keeping, selling, carrying, and importing gunpowder, nitroglycerin, and other explosive substances. And so we say it clearly complementary to the criminal offences, but not involving the sorts of criminal offences which endanger life or cause injury to the person or damage to property. The regulatory offences I think I might be right in saying carried a maximum penalty then of £50. If my Lords turn to page 135 in the paper bundle, 316 in the electronic bundle, paragraph 4 we respectfully submit is of significance. I beg your pardon, yes, section 4 as it was then, section 4 of that act. The manufacture of gunpowder shall not, nor shall any process of such manufacture be carried on except at a factory for gunpowder either lawfully existing or licensed for the same under this act. And then it goes on to provide an exemption, provided that nothing in this section shall apply to the making of a small quantity of gunpowder for the purpose of chemical experiment and not for practical use or sale. And similarly, an exemption for the possession of gunpowder, and as I shall explain, an explosive substance in section 5. Gunpowder shall not be kept at any place except as follows. That's to say, in the factory, 1, in a magazine or store, 2, registered premises, 3. Again, an exemption provided that this section shall not apply to a person keeping for his private use and not for sale gunpowder to an amount not exceeding on the same premises £30.
I wonder, I don't want to take you out of your way, but I'm wondering how it is possible to focus what the difference is between your respective positions. I mean, we see here in the proviso identification of the purpose of chemical experiment. Now, I don't know, but I rather imagine that there won't be much dispute that the purpose of chemical experiment can be a lawful object for the purposes of the 1883 Act. You know, obviously, there are, for example, the Fort Halstead is where experiments of that kind are carried out, and it must be
Yes.
a lawful object. it may be the difference between you, I don't know, but it may relate more to the circumstances under which chemical experiments are being carried out rather than that as an abstract, the lawfulness of that purpose in the abstract. Am I right?
I think what is,
I think
it is right.
Mr. Marby is nodding. So it sounds as though if this sort of experiment were being carried on by, I don't know, a university chemistry department,
Yes.
for example, that would be accepted, I see, as being a lawful object.
Yes.
It's the fact it's being carried on by, as it were, an amateur in his back garden that seems to be... Am I right in thinking, Mr. Marby, that's the focus of the problem? Right.
Well, that's extremely helpful. I can turn, perhaps, to that particular point immediately, and I do so by reference to the respondents' submissions, effectively, that one can distinguish the two situations, one, the chemistry department or any institutional situation in which someone is carrying out experiments, and a private individual who is carrying out experiments in his own laboratory on his own premises. The submissions made by the respondent are that that would not provide a lawful object. The latter of the two would not provide a lawful object, and in particular in the circumstances of this case, would not provide a lawful object. And in the terms of the respondent's submission, which are found at the respondent's written case, which is at page 19E, electronic bundle 412. As I understand the submissions, they are at paragraph 28 at paragraph 28 at page 18, electronic bundle 411. I should emphasise, perhaps before I take your lordships to that paragraph, that the appellant's case is that there may be a qualitative distinction between the two scenarios posed, but not a legal distinction. The respondent firstly suggests that there is no object, that the defence statement does not disclose an object. And secondly, at paragraph 32, that if it does disclose an object, the circumstances demonstrate that that object is not a lawful object. And our answer to those submissions are as follows. that firstly, experimentation, education, teaching oneself chemistry, as it were, is an object. And it's an object which has been advanced in the defence statement, so that if there were to be a trial, that object would be advanced evidentially. It is no different an object to the first scenario involving an academic or commercial institution and a person carrying out experiments in such circumstances. We submit that the difference is qualitative only, not in principle. And that there is nothing in the Act of 1883, which excludes an object such as experimentation or education. The second aspect of the respondent's submission is that, assuming that education, experimentation are objects, they are not, in the particular circumstances of this case, lawful objects. And as I understand the respondent's case, that submission is premised upon a number of factors which are set out in paragraphs 32 to 35, and they include the suggestion that the explosive detonation in the appellant's garden would not be in a controlled environment, and that's at paragraph 32, that the detonation would involve an inherent risk of injury or damage to property, also at paragraph 32, that such activity would involve the commission of other offences, for example, criminal damage, again at paragraph 32 of the respondent's case. And then at paragraphs 33 and 35 of the respondent's case, the uncertainty as to the consequences of the use of what is referred to in both those paragraphs as a highly dangerous subject, a highly dangerous substance. And the submission, as I understand it, is that in those circumstances, the object of experimentation could not be a lawful object. I say could not be, because the prosecution, the respondent urges the court, as indeed in the lower court, to find that there is no tenable defence, not that there is any requirement for an assessment of the factors just mentioned, but there is no tenable defence at all. And we respond in these ways. Firstly, we say they are evidential matters and not matters of law. I remind your lordships of the way in which this case has proceeded in the statement of facts and issues, which is the core bundle, tab 3, page 58, at electronic page 67, and at
Paragraph?
it's page 58 of the core bundle. It's tab 3.
I've got the document. Just which paragraph you refer to?
The statement of facts and issues, paragraph 1.3, which sets out the factual background in which it is said that the particular substance is a sensitive primary high explosive that can easily be detonated from a spark, friction, or impact, and it has no commercial applications. But that paragraph goes on to say this, that no measurement or estimate of the quantities seized has been made by a prosecution witness, and while the potential for HMTD to cause injury or damage to property is unlikely to be doubted, the photographic evidence suggests that they are very small amounts, probably less than 10 grams, potentially carrying a risk of insubstantial injury or damage. It's put in that way because there is simply an absence of evidence as to, firstly, the quantity, and secondly, the effect of such a quantity being detonated.
And presumably smaller quantities could have been used, we just don't know. We
We don't know at all. the issue as to the quantity and its explosive impact has been apparent for an extremely long time in these proceedings, and as far as we're aware, that the respondent has not produced any further evidence dealing with that issue. But the point...
He took mobile phone pictures
Yes,
of the explosion of
Yes.
the garden.
yes.
Do
Well, yes,
do we know what they suggest?
yes. Most of them appeared to be the equivalent of a damp firework, and one of them had an explosive effect of material emanating, I think it was from a bottle, 2 or 3 feet into the air. That, I should add, was not HMTD, that was another explosive substance.
But the experimentation, which the defence say was the lawful object, was causing the explosion, nothing else.
It was to analyse the way in which the concoction of explosive substances worked in order to understand and educate himself. And for that purpose, it was necessary to demonstrate to himself the efficacy or otherwise of the concoction fabricated in his makeshift laboratory.
It sounds from paragraph 1.5 as though he'd been experimenting with different
Yes.
means of detonating.
Yes.
One being to use small detonators by filling fairy lights with firework powder, and another you would see on films like the ones he's spoken about is to detonate it using
Yes.
a mobile phone
Yes.
signal.
Yes.
Do you dispute that detonation in the back garden may involve the offences identified?
Well, we do insofar as there is an absence of evidence suggesting that is a possible outcome. But we would emphasise this, and if I can make these points, the 2 Petri dishes on which the HMTD was found were themselves small, and it is possible, without any measurement having been taken, that one is concerned here with maybe a gram or 2 only. We simply don't know, but from a visual perspective and for the untrained eye of counsel, it's quite possible that we are concerned with a couple of grams only. There is no evidence as to the potential for injury or damage of that quantity on ignition. And therefore we say that there is no evidence that such a quantity could be regarded in the terms of the respondent's case as highly dangerous.
I mean, you don't have to go that far, do you? I'm not. I mean, the case of paragraph 33,
Yes.
they're saying, well, this is simply a matter, it's not possible for you to demonstrate that, and therefore you can't bring yourself within the defence. You say, well, that's a question for trial.
It's a matter for the trial. We would go further, in fact, and say that if, for example, the facts were agreed that these were indeed his objects, then the prosecution case may founder on the basis that they could not prove that there was an unlawful purpose. And one wouldn't need to even to get to the point where the defendant would need to raise his defence.
But the prosecution wouldn't have to prove a specific unlawful purpose, would they?
No.
It would be enough that the circumstances gave rise to a reasonable suspicion
Yes.
that they were possessed for such a...
I of course accept that. But if, for example, there were no dispute as to the object, and there was no dispute in effect as to the effect of the satisfaction of that object, then one might be able to say that the prosecution would not get beyond the halfway stage of the trial. But in the context of the respondents' assertions, we say that it would be pure conjecture that the potential impact might be any more than, for example, a burn to the appellant or to a work surface that he was using. It would be conjecture to say that the ignition of these small amounts of HMTD could be any more dangerous than, say, striking a match.
Once it's accepted, as the Crown accept, that in principle the purpose of chemical experiment, as it's put in the 1875 Act, can be a lawful object, provided it's being carried out in circumstances where proper precautions are being taken. A controlled environment, as they put it, then I'd have thought it becomes a question of fact whether the circumstances are such that any particular precautions are necessary.
Well, that's our position.
I mean, no doubt there will be elaborate precautions when commercial quantities
Yes.
of explosives are being tested by experiment.
Well,
But
certainly
if
that's...
what you're talking about is the equivalent of a firework, then it's a different...
Well, we say there is no suggestion that this is any more dangerous than a firework. Indeed, it's quite possible, if not probable, that the potential damage or danger of injury is substantially less. But I would add to that, of course, that in order to have an unlawful purpose, the effect associated with the detonation of an explosive must be on a third person. Because, of course, injuring oneself or damaging one's own garden table, for example, would not be an unlawful purpose. And therefore, even if there was a risk of injury or damage, there's no evidence that it might cause injury to anyone else, or it might cause damage to anyone else's property. But we submit we can go beyond the consideration of that type of factual issue to say this, that even if there was evidence suggesting that there was an associated risk of injury to a third person or damage to a third person's property, that would not constitute the appellant's object or purpose unless he recognised that risk and nevertheless went on to take it.
His purpose was to cause an explosion.
Yes.
And that explosion might have injured somebody, or might not.
That's absolutely right. But we would say that if the injury to someone else or the damage to someone else's property was unintended and unforeseen, then it can't be said that that would be his purpose, as it were, by default. We suggest that, indeed, if one looks at the suggested unlawfulness that the respondent relies upon, which is the Criminal Damage Act, Section 1 of the Criminal Damage Act, by which it is an offence to intentionally damage another person's property or to be reckless as to another person's property. In this case, there would be no evidence of an intention to damage another person's property. And as my lords, I'm sure, will know, that in order to establish recklessness, that requires an awareness of the risk of damage to let's say, a neighbour's garden fence. That would have to be shown, we respectfully submit, in order for the respondent to be able to say that, firstly, that risk was an inevitable consequence as a fact of the detonation, and secondly, that within the defendant's purpose or object was such an outcome.
You would say there's no risk here because quantities involved are so minute that
Yes.
simply isn't a risk.
Our first position is that, as a matter of fact, there is no evidence to suggest there was a risk at all. But even if there was objectively a risk to damage to a third person's property, in order for that risk to be a part or an aspect of the defendant's object or purpose, it would have to be shown that he recognised that that risk existed, and nevertheless his purpose was to continue to take that risk.
So you say that if the defendant did not intend or was not reckless as to the risk of criminal injury
Yes.
or damage, then it's not an unlawful object.
Correct. That's our submission.
Thank you.
You don't have to go as far as that. do you?
I don't, no.
Um,
I only do so in case that there are alternative findings against me on other grounds, but I don't. I respectfully agree with my lord that there is simply no evidence on which to found a case of associated unlawfulness.
I mean, if you take it in stages, if it's a lawful object, if chemical experiment is a lawful object in circumstances where it's being done in a university laboratory, then it must be equally lawful if it's being done by a private citizen who has equipped himself with a comparable laboratory.
Yes.
Mustn't it?
Well, that's our
I mean, otherwise,
starting
how does
point.
Charles Darwin ever, or
Well,
any private scientist
well,
ever
Or indeed Roger Bacon.
Yes.
yes.
Well, we accept that. Indeed, that is the fundamental premise of our submissions, that while there may be a qualitative difference between the private individual experimenting at home in a garden shed in a makeshift laboratory.
Well, not necessarily makeshift. I mean, there are people who
Yes.
are inventors, who have laboratories in their gardens and actually invent things, and some of them earn very large amounts of money for their inventions.
Well, Lord, I respectfully agree, and I have referred, my Lords, to the Health and Safety Executive Guidelines in relation to the handling of explosives. And in order, in part, to advance the position that our submission is not simply a theoretical one, it is a practical one. And, Lord, if I can take your lordships to it now, and I appreciate that ordinarily these materials would only be of application if there was some ambiguity in the meaning of a statutory term. We say that does apply here because one is concerned with the meaning of a lawful object and one is concerned with the meaning of the exemptions in the explosives regulations. But, Lords, at the Authorities Bundle, tab 21, which is page 190 and 385 in the electronic bundle. In fact, I didn't take, my Lords, to the regulations themselves, and perhaps before I take, my Lords, to the...
What's your point going to be?
The point is that it's recognised in the explanatory memorandum and the guidance from the HSE that there are private individuals who carry out experiments.
Well, let's see that. I mean, it seems a very obvious point.
Well, and for example, at page 192 and 387 of the electronic bundle, one sees that.
Sorry,
paragraph 7.1, one sees the reference policy background to the explosives and acetylene sectors being by nature fragmented and diverse, ranging from storage and manufacture of large amounts of highly energetic and flammable material to individual hobbyists. If one goes back to divider 19, page 174, the paper bundle, divider 19, page 174, and 365 in the electronic bundle, that provides the first few pages. I think it runs, one can see, to 114 pages in total, but the first few pages of the safety provisions guidance on the regulations, and at page 180, electronic bundle 371 at paragraph 9 at the bottom of the page, one sees reference to duty holders, including private individuals, and then over the page, at page 181, paragraph 13, one sees under the heading Explosives for Work, Personal and Recreational Use, the regulations of 2014 applying to explosives operations, whether they are for work or non-work purposes. They therefore apply to anyone storing explosives for personal recreational use, or to voluntary clubs or societies storing explosives, and then it gives examples. And that, and I don't take my lords to it now, but at tab 20 there is a further document which is the security provisions guidance, which says very much the same thing.
I suppose whether you're a explosives manufacturer, for example, or simply a hobbyist, your activities are going to be regulated.
Yes.
And if you fail to comply with the regulations, then your possession of the explosives with the intent to experiment with them under conditions which are a breach of the regulations would not be a lawful object.
It would not be an unlawful object.
Sorry, not be a lawful object.
It would not be an unlawful object.
Why not?
Would it not? Where we seem to be is that it's not enough simply to say, my purpose is chemical experimentation.
Yes.
Because that might or might not be a lawful object depending on whether the circumstances in which the experiment is to be carried on would be lawful or unlawful. And that would be a matter that depended primarily on compliance with the regulatory framework.
Well, we would say that would not be an unlawful object. And we rely upon the cases of Fegan and the Attorney General's reference, in which, I can take my lords to that in a moment, in which the possession, firstly, of a petrol bomb in one case, and secondly, a firearm in circumstances where the appellant in those cases was saying that he had possession of those objects for a lawful object, namely self-defense. It was held in both that it's possible to be in unlawful possession, or presumably possible to have manufactured a substance unlawfully, but nevertheless to have a lawful object.
So what the only issue would be whether he was in breach of the regulations.
Yes.
It wouldn't bring him under this
Yes.
particular provision.
Yes.
Yeah.
In both those cases, I think I'm right in saying that there really was no dispute that the possession of the petrol bomb itself was unlawful, and the possession of the firearm without a certificate was unlawful. But in both cases, firstly, Lord McDermott in the Northern Ireland Court of Appeal, and secondly, Lord Lane, Lord Chief Justice, said that the two are not incompatible, that the purpose is not necessarily rendered unlawful simply because the possession or the manufacture is unlawful. I don't know whether my lords wish
They said in this case the converse applies. You can possess something lawfully for an unlawful purpose, just as you can possess something unlawfully for a lawful.
Well, we would say that, firstly, it's not established that the appellant behaved unlawfully. It's not been part of the prosecution case that he behaved unlawfully in relation to the manufacture or possession. It may be, judging by the huge number of regulations, not surprisingly, which need to be complied with under the 2014 regulations, that he has committed a regulatory offence under the Health and Safety Act. Under Section 33, it would be an offence to have committed a breach of the regulations, for which the maximum penalty would be 2 years imprisonment.
No, that's not part of the case against.
But that's not part of the case against, and we accept that it's quite possible, nevertheless,
But the Criminal Damage Act points, which are brought up now in paragraph 32, were they part of the case in the Court of Appeal, or was that a new point?
No.
And your answer to that is, well, there's no reason to think that on the quantities and what we know here, that there was any criminal damage risk.
Firstly, that. Yeah. Secondly, that if there was to be criminal damage, almost certainly it would be confined to the the appellant's own property. And thirdly, in any event, as I have submitted, that unless it was his object or purpose to injure a third person, or unless he perceived that there was a risk of doing that and nevertheless went on to take that risk, it could not be said that he had an unlawful purpose.
What about public nuisance?
Well, I've not descended into public nuisance because we would submit the same principle applies. If a loud bang was to represent a public nuisance, one would have to explore questions of whether or not the defendant knew that there would be a loud bang and whether or not that would in fact cause a nuisance to a neighbour sitting in his or her garden.
But what's the intent, the mental requirement of public nuisance?
My Lord, I've not examined that simply because these are examples which not form part of the prosecution case and did not form part of the rationale for the decision made in the Court of Appeal. What we would say, as we've said in relation to criminal damage, is that if that unlawful purpose was to be associated necessarily with the purpose of experimentation and education, it would have to be shown that that he intended to cause a public nuisance in order to come within the term purpose or object, or at the very least was aware that it would or might cause a nuisance, but nevertheless proceeded with the detonation knowing that it could cause a public nuisance. And we say there is simply no evidence. It's not a prosecution case, or at least it hasn't been the prosecution case until a week or two ago when we received the respondent's notice. And there is no no evidence to support the evidential factor on which the Crown now makes its case on lawfulness.
Well, it's your case. You have the burden of proof of showing it's a lawful object. So you have to show, don't you, that the intended detonation is not going to involve
Yes.
any offence.
Well, that he didn't intend it to cause a public nuisance, or that if it may have or would have caused a public nuisance, he realised that and nevertheless decided to continue with the detonation.
There must be a limit to the amount which you have to dig around to find possible criminal offences which the prosecution haven't brought up even now.
Well, we respectfully
At least I would have thought
agree.
so.
But can I take my lords to the case?
Could I just ask you this,
Yes.
before we do that? Does it have to be a criminal offence before one could conclude that it was an unlawful object?
We have assumed that that is the case, simply because of the context in which Section 4 appears, namely the earlier sections deal with endangering life or damage to property or serious damage to property or serious injury. And the rationale for Section 4 we submit is that in circumstances where a person is found with a quantity of explosive substance and the prosecution are unable to prove whether that is to kill someone or to maim someone or to blow up a public building, and they have no evidence one way or the other, but the circumstances are sufficiently suspicious as to give rise to the likelihood that one of those purposes must have been in the mind of the
Yes, I think it's being
suspect.
put to you that there may be some other forms of illegality
Yes.
that are not criminal. Has that been suggested by anyone?
I've not
Is it
seen any
not?
suggestion of that. I've seen no authority for that proposition.
I mean, you start from the position that in this country at least, that which is not prescribed by law
Yes.
is lawful.
Exactly.
Indeed, but the point has been raised already. It was the first issue in the Court of Appeal as to the boundary between lawful object and unlawful object.
Yes.
Yes, do you understand that?
Our submission is that there is
No.
no gap between the two. That if activity is prescribed, it's unlawful. If it's not, it is lawful. But to answer the point raised in relation to an ancillary consequence, unintended, of the detonation of an explosive substance, may I take my lords to the case of Campbell, which is at the Authorities Bundle, tab 7, page 225. This, in fact, it's at Electronic Bundle 225. Well, in fact, it's the wrong case. It's the case of Cook. My apologies. Which is at tab
It's
4,
tab 4.
page 49 and 201 in the electronic bundle. And this wasn't a Section 4.1 case. This was a case involving the possession of a police uniform, contrary to Section 93 of the Police Act. And, Lords, at page 50, the 202 in the electronic bundle, that the offence is set out, and it's of relevance because that created the offence of being in possession of an article of police uniform, not being a member of the police force, unless the accused proves he's obtained possession of that article lawfully and, more importantly, has possession of it for a lawful purpose. And the question of lawful purpose was considered in the divisional court in those proceedings. Paragraph 12, Mr. Justice Mitting said this: "For my part, I accept that the lawful purpose or purposes for which articles of police uniform are obtained and possessed must be a positive purpose. I do not, however, accept that the purpose must be narrowly construed." And then he goes on to give examples of how one might rely upon the defence of lawful purpose in a number of different circumstances. And the point relating to the ancillary unlawfulness really is made at paragraph 13. The possession of articles of police uniform for the purpose of supply, whether by way of sale or otherwise, to an end user who intends to use them for an unlawful purpose, including, for example, impersonating a police officer with intent to deceive, would on the face of it be an unlawful purpose. Because this is a criminal offence, there must be an element of mens rea. Possession for the purpose of sale to someone who, unknown to the seller, had such an unlawful purpose would not be, unless, as the Crown Court found, he was obliged to carry out a series of checks and issue warnings. The burden of proving the absence of necessary mens rea is, of course, on him. The formulation from which Mr. Penny, who represented the Crown in that case, does not dissent, and Mr. Hill certainly does not, is that if the seller proves that he neither knew nor had reason to believe the end user to whom he was selling had an unlawful purpose in mind, then subject to the requirement to carry out checks, the burden of proving the absence of mens rea would be discharged. And as Mr. Justice Mitting later found, that there was no requirement to carry out the checks. But we use that as an analogy in these proceedings and in relation to the submissions we make. It is, and it's this, that unless the purpose encompassed a realization that the unlawful object might occur, the defendant is entitled to rely upon the defence of lawful object.
But you would have to show there was no such realisation, wouldn't you? Are you accepting
Yes.
you have to prove the absence
Yes.
of mens rea?
Yes. I should add, perhaps, that had the associative unlawful purpose been an aspect of the prosecution's case, either in respect of Criminal Damage Act or some other form of criminal misconduct, we would undoubtedly have dealt with it in our defence statement. But as I say, it has not hitherto been argued that the associative unlawfulness renders an otherwise lawful object unlawful, and therefore we've not, as I say, hitherto dealt with it.
Well, the cases of Fegan and the Attorney General's reference are really quite strong authorities to that effect. I mean, Fegan, the defendant was in unlawful possession of a firearm,
Yes.
but nonetheless he possessed it for a lawful object.
Yes, exactly.
And the Attorney General's reference, which was the man who was in lawful possession of, Attorney General's reference is about the man who is in possession of petrol bombs
Yes.
for a lawful object. And the way the Lord Chief Justice put it, I see on page 48, is he may arm himself for his own protection, although in so doing he may commit other offences, that he may be guilty of other offences will avoid the risk of anarchy contemplated by the reference. So in other words, in a case like this, it may be that other offences will be committed,
Yes.
but if you focus on the object of the
Yes.
possession and ask whether that's lawful, and you answer that positively, then it's irrelevant that other offences might be committed.
Well, that's our submission. It's possible to go a stage further, perhaps. On the respondent's case, it is perfectly possible for a hobbyist or a person who is experimenting in his garden shed, who is fully compliant with the regulations, nevertheless, on the respondent's case, to be guilty of a Section 4 offence. And as Lord MacDermott pointed out in the case of Fegan, Divider 5, page 209, beyond saying that it's electronic page 200, beg your pardon, electronic page 209, paper page 55, at the bottom of the page, going beyond the proposition that one may be in unlawful possession of an explosive substance and yet still have a lawful object. He poses the converse at the very bottom of page 58, electronic page 212. He says, a firearm in lawful possession may undoubtedly be possessed for an unlawful object, and there seems no good reason why the converse should not be equally true. And we suggest that on the respondent's case, it would be perfectly possible for a private individual not working in an academic or commercial institution to have complied with all of the regulations and nevertheless have an unlawful object on the respondent's case, which is education and experimentation. Well, I think I've almost dealt with the matters that I was going to raise, but subject to one or two further final matters. One is the question of whether or not there exists such a category of lawful objects as a positive lawful object, and if so, whether that would be compliant with the requirement that criminal offences should be accessible and certain. In the case of riding, which was relied upon and followed in the court below, the suggestion was made, indeed the decision was based upon the assertion that in Section 4.1, a lawful object must be a positive or affirmative object which was lawful. Well, the reference to it in the court below is in the core bundle it's at page 79, which is behind divider 7. Behind divider 7 at page 69, I beg your pardon, 69, and electronic bundle 89. And at paragraph 42, which understand is being relied upon by the respondent. Paragraph 42, which is at page 79, the court said this: in summary, we conclude that riding was not decided per incuriam, the various cases relied upon the applicant. And my lords, if I can interrupt myself there by saying that those cases were cases in which it was held, not least in Bury in the House of Lords, that not lawful was the same as unlawful. The judgment in the court below continued, we accept that a person in possession of explosives must show, on a balance of probabilities, that he or she has an affirmative or positive object for possessing those explosives. And it's our submission that if by positive or affirmative object, which is lawful, what is meant is simply to emphasize that there must be an object or a purpose rather than absence of purpose, then we respectfully agree. But we submit that there is no category of affirmative object or positive object. A purpose requires no adjectival addition. And indeed, one couldn't, we say, begin to understand what might be understood by the converse, namely a negative object. If, on the other hand, what was intended by the use of the expression positive or affirmative object was a separate category or a subcategory of objects, then we respectfully submit that is wrong in principle and is not necessary, not based upon any natural reading of section 4.1. And the examples that are deployed in the court below are those cases of Fegan and Attorney General's reference, and indeed the case of Bury. In the first two cases, as the court has observed, it was held that self-defense was a lawful object, but we submit that in both of those cases, the court was concerned with an exception to conduct that would be otherwise unlawful. It is unlawful to harm or injure another person, but as an exception to that unlawfulness, one may use reasonable self-defense. Similarly, in Bury, which was cited in the court below as a paradigm example of positive or an affirmative object which was lawful, that too was an exception to conduct which was otherwise unlawful. That involved prohibitions on the export of explosive substances. And in that case, the appellant was relying upon an exception to otherwise unlawful conduct. And we say that those examples, particularly the last, which is described as a paradigm example in the court below, are not especially good examples of lawful conduct, and that lawful conduct is not limited to exceptions to otherwise unlawful conduct.
It's confusing to speak of lawful conduct. I mean, the conduct of Mr. Fegan was unlawful.
Yes.
But his object in possessing the revolver and ammunition was a lawful object.
Lord is absolutely right. I should have used the word purpose or object. The object of injuring someone or the object of exporting explosive substance in in certain circumstances would generally be regarded as unlawful. And each of those three cases relies upon lawfulness and explains it as positive lawfulness merely by reference to the fact that the lawfulness derives from an exception to an object which would otherwise be unlawful. But we say that those are not good examples. They are correct examples, but they are not good examples of lawful conduct.
So, I mean, the positive, I mean, in riding, the defence was that I was curious and just experiment.
Yes.
And the court said that's not capable of being, quote, a positive purpose, whatever
Yes.
that means. I mean, of course, the 1875 Act, which you showed us, clearly assumes that the purpose of chemical experiment is a
Yes.
lawful purpose, and presumably is thinking of something rather more formal than Mr. Riding was thinking of. But, I mean, is your case that if it has to be a positive purpose, then what this defendant was doing was indeed a positive purpose?
It was. It was a positive purpose, but insofar as the addition of the term positive adds something, it's difficult to discern what precisely that could be. And
it's not in the statute, anyway.
It's not in the statute, and our concern would be that it would be very difficult to discern what conduct is positive conduct.
Yeah, we've got that, but I mean, do you say that Riding was wrong? And you have to say that.
We say Riding was wrong, and the reason is that it misinterpreted a part of the judgment in Fegan, Lord.
It doesn't matter why it was wrong, if it was wrong.
Well, it may be important. But it's clear that in Riding, my Lord, at page at divider 9, page 92A, and at 259 in the electronic bundle. When at paragraph 12 at page 94, Lord Justice Hughes, as he then was, said, in the end, therefore, the proposition boils down to the submission that lawful object means the absence of criminal purpose rather than a positive object which is lawful. And I should say that it has never been the appellant's case that he relies upon an absence of evidence of unlawful purpose. He positively does rely upon a lawful object. But at the end of that paragraph, Lord Hughes went on to say this in reference to the case of Fegan. There, Lord McDermott, at page 194, explicitly addressed the question before us. Once again, it was a case in which self-defence was asserted as the lawful object. The learned Lord Justice said this: as a matter of construction, a defence under the second limb of section 4.1 cannot be made by the possessor proving that he had no unlawful object. The onus resting on him is specific but positive. He has to show possession for a lawful object. And we respectfully agree with that dictum, that a defendant cannot simply say, I have no unlawful purpose. The rationale for section 41 is that the tribunal of fact must be in a position to know what the defendant's object was, to make a decision as to whether or not that indeed was his or her true object, or whether he's trying to pull the wool over the tribunal's eyes, and then to decide whether or not that object was a lawful object. And to that extent, we entirely agree with the dictum. However, what appears to have happened is that that dictum was relied upon as the proposition that it was necessary for a defendant to prove positive object, which was lawful. And if that's right, we respectfully submit that that was a misinterpretation of that dictum. It's clear from that dictum that what Lord MacDermot was saying was that it related to the burden of proof. That you cannot make out the defence by proving no unlawful object. The onus, in other words, the burden of proving that defence, rested on the defendant, and it was specific and positive. And it seems that that's where the suggestion that a positive object is necessary, and insofar as it means simply that a defendant firstly must specify what that object is, and secondly must establish it evidentially, in other words, by positively advancing that object. Insofar as that is the correct interpretation, we have no issue. But what appears to have happened...
Presumably you would accept that it has to be a credible purpose.
Well, exactly.
And one might possibly...
It would have to be a credible...
Riding might be upheld on that basis, that
yes.
you have a pipe bomb which has on it the words killer.
Yes.
Mere curiosity seems slightly surprising.
Lord, yes, and of course, as I say, it is absolutely necessary, in order to rely upon the Section 4.1 defence, to specify what that object is, and to do so positively in the sense that that must be advanced evidentially, because without those two features, those two requirements, the onus of which falls on the defendant being presented to a court, the court would have no means of measuring whether or not the object that is advanced is a credible one, or indeed whether it is true or lawful. So our submission is that if that dictum is taken to mean anything else, it is a misreading of what Lord MacDermot was saying, and that in the misreading of it, if, as appears to be suggested by both Riding and in the court below, that dictum is consistent with a different interpretation of Section 6.4, such as to require a defendant to show a positive object or an affirmative object, the meaning of which is, we submit, unclear, then that is a misreading of that. And indeed, as I have said, and I perhaps needn't take the Lords to it now, but as I've said in the submissions we've made, if that was a correct meaning of lawful object, a positive lawful object, it would be very difficult to understand where one would find the answer to the question, well, what is a positive or affirmative lawful object? And indeed, it might be suggested, and indeed it appears to have been the case in the court below, that it can only create confusion, firstly by adding an adjective which is entirely unnecessary, because a purpose is self-evidently, or an object is self-evidently positive, and secondly leads potentially to a further misreading of that expression positive lawful object by associating the word positive to lawful instead of positive to object.
Well, as I understand it, the Court of Appeal interpret positive as meaning you've got to show the use to which the explosives will be put. In other words, it's not enough to say experimentation, you've got to say how you're going to experiment. And as I understand it, you accept that. You say the object here was experimentation through detonation. That's the use.
Yes. That is the use. Of course, the term object could include a wide variety of different states of mind that the possessor could hold simultaneously. It could include curiosity, it could include interest, and for that reason it's not necessarily that straightforward in identifying with particularity a precise object which might come within section 4.1. But if the object was to be defined in any other way, such as a positive object, then it seems to us that it will be difficult not only to discern what is a positive object or what is an affirmative object. It would be difficult indeed for a judge giving judicial directions to a jury to be able to say, in summing up, all members of the jury, it's not good enough that there should be a lawful object. What has to be proved by the defendant is a positive lawful object. And for my own part, it would seem very difficult for a judge to be able to provide a workable definition to the jury. And
But
indeed,
in this case, it's not simply detonation in the sense of creating a bang. If he's, for example, learning how to trigger the detonation by using a mobile phone, then there's some quite sophisticated electronics going on here,
yes,
and as well as the chemistry.
as well as the chemistry, indeed. I don't know whether the court has seen that the film on which the defendant became obsessively fixated, but clearly that it was an Oscar-winning film, I should add. It's clear that one would need to understand the workings of that sort of electronic device in order to understand how the bomb disposal team were able to do what they did. May I finally say that in the context of, firstly, whether there is such an expression or term as a positive lawful object, and secondly, in the context of any sort of finding as to whether a particular type of conduct is lawful or not. It would be, looking at it from the perspective of a trial, very difficult and possibly inappropriate for the jury to be asked to distinguish between a person who was employed or not employed, a person who was paid or not paid, a person who was working in a formal institutional setting, or a person who had established his or her own laboratory. And we say that not only would it be difficult to make judgments of lawfulness based upon those sorts of issues, it would be inappropriate when ultimately the issue is one of principle, and provided that the object is in principle lawful, perhaps unless it can be shown that there is an associated unlawful element which the defendant would be pursuing, known to him, then we submit that in all other cases that the matter should be left to the jury and not, as in this case, withdrawn from the jury.
I was wondering whether the width of the definition of explosive substance in Section 9 of the 1883 Act helps you with that submission, because it seems to be very wide. This is page 147 in the paper bundle, so I don't have the electronic reference. So Section 9.1 says, the expression explosive substance shall be deemed to include any materials for making any explosive substance, any apparatus, machine, implement, and so on. Sorry, page 147.
Yeah. Thank you.
So we're dealing with someone who's got to the stage of producing something which is in itself highly explosive.
Yes.
But the definition seems very wide and would catch people, well before you get to that stage.
Yes.
Which I was just wondering whether that somewhat supports your submission about the importance of focus on the object as the an important controlling feature of this offence.
Well, we respectfully agree, although we hadn't, in fact, concentrated or even observed that might be of assistance. Clearly, now that we have seen it.
I was really picking up what you were saying about the difference between commercial laboratories or university laboratories and private individuals. It seems to me that any attempted distinction based upon those categories comes under more and more pressure the wider the range of substances which are being caught within the purview of the Act.
Yeah.
We respectfully agree.
With lemons, for example. I mean, if citric acid is required in this to make what he made, then lemons would be explosive substances if they were intended for that use.
Well, we respectfully agree with that, and we would add only this in the context of criminal offences, that it is important to recognise that they should not be construed more widely than is necessary or indicated by the natural meaning of the words of the statute. And equally, when dealing with defences, statutory defences to criminal offences, they should not be construed more narrowly than is necessary to give effect to the intention of Parliament. And we finally submit...
Sorry, just on that, in your printed case, you focus upon, I think it was Article 7 of the European Convention, but I mean, is there not a domestic principle? Benjamin gives it the name Principle Against Doubtful Penalisation, which is essentially to the same effect.
It is.
That you need criminal penalties to be clearly defined as a matter of principle.
Lord, that's right. We submit both at common law and under Article 7. Any gloss on the phrase lawful object would give rise to uncertainty and therefore offend both the principle of common law and Article 7. And we would add that the importance of not having a definition of the offence drawn too widely, and the importance of not having a statutory defence drawn too narrowly is supported by the very limited nature of the mens rea in this case. Ordinarily, in order to establish a criminal offence, particularly one of this gravity which carries a sentence of life imprisonment, the prosecution have to prove the case beyond reasonable doubt. I mean, in this case, the mens rea, which is, whether you look at it from the prosecution perspective or the statutory defence perspective, is possession of an unlawful object. But the standard of proof isn't a requirement that should be established beyond reasonable doubt, or a requirement even that it be established on a balance of probabilities. The requirement under Section 4 is simply that it is established that there is a reasonable suspicion that that is the state of mind of the accused person.
Well, presumably that reflects the seriousness of the mischief which it was intended to address.
Well, the mischief, we say, is the uncertainty, the uncertainty as to the particular object that the accused person possesses. Yes, it would not be possible for the prosecution to prove a specific intention either to damage property, injure a person, kill a person, and so on. In those circumstances, it does reflect the that position where the prosecution would find it difficult to make an assertion for fear of finding that wasn't the case, which is
I mean, Section 4 is intended to create a balance between prosecution
Yes.
and defence.
Yes.
I mean, it might be said that the seriousness of the harmful consequences if something goes wrong with the explosives is reflected in the width or the lowness of the threshold that the prosecution has to cross at the first stage of the test, essentially showing suspicious circumstances, not as to any particular object, but just generally.
Yes.
In perhaps one might summarise it by saying, it looks as though this person's up to no good.
Absolutely.
And then it shifts the onus back onto the defence, where they, as you pointed out, have the burden of proof. Of course, that would be according to the usual principles of what standard of proof they have to meet in discharging that burden, where they have to identify a specific object.
Yes.
But you say they do that by saying, well, I intended to use it for this. Yes. And then the test is, well, is the this something which is unlawful or not,
yes,
as used in those particular circumstances?
Yes, indeed. That's exactly how we accept it works. And the point I was simply making is that the statutory defence should not be drawn more narrowly than is necessary, because the hurdle the prosecution have to jump in order to get to that stage in terms of mens rea is an exceedingly low one. It is as close to strict liability as one can get. And for those reasons, any narrowing of the interpretation of the statutory defence in Section 4.1 we respectfully submit should not be permitted. So those are the submissions, unless there are any further.
No, thank you very much, Mr. Bogan. Ms. Marby. Oh, I see. Well, time flies. We'll sit again at 2:00.